You're welcome back, and you're still watching Newsnight. We're live from Nigeria's capital in Abuja. I'm Christian Ogodo. Thanks for staying with us. And citing the need to dispense with appeals arising from the general election, the Supreme Court has shifted hearing of applications seeking to compel the Apex Court to give effect to its earlier judgment that All Progressives Congress and Action People's Party both nominated Uche Nwosu for the 2019 governorship election to December 5th, 2023, after the Imo State governorship election would have held on November 11. This sudden postponement, however, has become a source of concern for stakeholders. Arise news analyst Frank Tietie, lawyer, is here to look at the issues. Frank, just 24 hours ago, we were on this same issue, and now we have a Supreme Court that is going to be depleted to 10 men come 27th of this month, when Justice Ataijo would be retiring. How is this going to affect the recs of this Imo State case?
It doesn't. It's not in any way. So long as a panel of 7 can always be constituted, the Supreme Court will have jurisdiction to hear any matter in terms of composition. 10 is still a very good number, and
with the plethora of work that they have.
You see, what people don't understand is that the Supreme Court doesn't hear. It's not a regular court that hears cases. It doesn't take witnesses from. It doesn't take evidence from witnesses. It's the briefs. It reads briefs and reaches conclusions, and then it writes the supporting positions for its decisions, the reason that for every decision it takes. So it's supposed to be quite easy. The expectation is that every Supreme Court justice has quite a large number of support staff, legal assistants and librarians, many typists, research assistants, people that help each justice to, in terms of support, to reach a decision, and then to also articulate those the reasons for those decisions in writing. So they have a quite array of competent persons who support them. So the expectation is, just like members of the National Assembly, they have serious resources that are made available for them to dispense justice adequately. So long as a panel of 5 can be considered for the regular cases, and then that of a number of 7, the Supreme Court will always be fine. The Supreme Court shouldn't have any reason to keep giving long dates for cases that have been filed before it, especially this particular Imo matter, which brought a lot of relief as at yesterday for me, a few days earlier, that it has decided to hear the case of challenging the nomination of Governor Hope Uzodinma, whether he was properly nominated as a candidate of the All Progressive Congress.
But there's a problem here that those who filed the case are apprehensive about, that the Supreme Court has shifted.
I very much doubt that.
Okay.
I very much doubt that. You see, as a practicing lawyer myself, I know how the registry of a court can sometimes undermine the head of a court. The head of a court is usually the chief judge in case of state high court, or the chief justice of Nigeria in case of the Supreme Court. So the registry of a court most likely can take certain decisions that are not in tandem, that are not in sync with what the head of court wants. Definitely, as at yesterday, I was here to praise the chief justice of Nigeria for giving a date to hear a matter, an application that was before it 3 years ago, that was crucial to the election, to the justice of the election of the Imo State governorship. And to think that reports which are unconfirmed as far as I'm concerned, because I haven't seen the service of any of such document or published anywhere, but I've been also made aware that such a document exists. However, that could be emanating only from the registry, but not necessarily from the head of the court. So on the expectation is that you don't expect the Supreme Court of Nigeria to announce that on the 31st of October 2023, it will hear the applications determining the validity of the election of Governor Hope Uzodinma. And then suddenly from nowhere, without any reason, it's saying that it's adjourning till after another election in Imo State. So the Supreme Court has had...
It will render that application or motion useless if
yes,
that happens.
Yes, and then again, what will Nigerians begin to think? I mean, sometimes the arms of government, I'm talking about the executive, legislature, and now the judiciary, can't operate. Sometimes they operate, and they shouldn't operate as if the people of Nigeria are non-existent. The judiciary is struggling with a serious moral baggage. And people like us are advocates all the time, forever. We will be advocates of the judiciary. That is, it should be, the sanctity and the integrity of the judiciary should be protected. But again, you can't expect that there will be obvious, direct infraction by the judiciary against itself. That kind of inconsistency will not be tolerated at all. So it will seem as if the judiciary has stepped down to become political and siding a clear injustice, whereas it is supposed to be the bastion of justice. So where is the justice? When at the time it could have resolved the matter before the election of Governor Hope Uzodinma, now it did not even listen. It did not even attempt to hear the appeal challenging, not only the appeal of PDP, because the issue is, remember, I dealt with the issues quite a lot yesterday, when Uche Nwosu was nominated by Action Alliance and at the same time was nominated by the All Progressive Congress, he was disqualified. And at that point, the APC did not have a candidate. So the PDP went to challenge. I mean, they had a pre-election matter at the Federal High Court in Abuja, challenging the propriety of the nomination of Uche Nwosu. When that matter got to the Supreme Court agreed that Uche Nwosu was not a candidate was not a proper candidate in the election. So the idea is that at what point did Hope Uzodinma become the candidate of the All Progressive Congress and later won as governor? Those kind of crucial issues ought to have been decided before an election. If it had not been decided in 3 years when an application is lying pending and the Supreme Court on its own, nobody pushed it. That's an interesting thing. Nobody pushed it, decided that, it should hear that appeal. It should hear that application before the November 11 election. And from nowhere, it decides again that, no, it's not hearing it again. It's something fishy is going on. I doubt very much that the Supreme Court will shoot itself in the foot by that kind of action until I am satisfied that that kind of direction is coming from the Chief Justice of Nigeria. I think you should be taken with just a pinch of salt.
So you think there's just the political interplay here?
Yes, and the Supreme Court...
Some kind of interference?
I think that there is an attempt to influence the Supreme Court. And the Supreme Court must do everything possible to resist it. I am a stickler and a fan of the fact that we will continue to manage our judiciary no matter how bad it is. Nevertheless, the judiciary cannot open itself to such kind of ridicule and total disrespect and disregard by Nigerians when it begins to constantly suspect that the justice delivery is interfered by, much political interference.
Oh, sometimes and when we say, mercantile interference.
Of course, when we say political interference, what are we talking about? The executive control fund. So, but must we? I doubt, because if you look at, if someone has become a justice of the Supreme Court, what else in this world can you use to tempt him? What sort of filthy lucre? Do justice for a country, because that's the foundation upon which a country can grow. Why the Supreme Court cannot lend itself as a state institution that will destroy democracy. Rather, it should pride itself as the institution that has preserved democracy, that has improved our politics. But to think that it will shift, it is a shifting court that is unpredictable, that is uncertain, to the extent that it gives a date and it engenders a lot of hope for some certainty, for some fairness in Imo State, and then suddenly there are rumors everywhere that no, it doesn't want to give the judgment anymore. So why would a court run away from giving judgment in a particular application before it. It was run away from 1 year, 2 years, 3 years, and then it has the opportunity before an election is held, and then suddenly it says, no, it does not want to. Why? The same thing is said of the many, and I also want to consider that this is coming from the grapevine, that many justices of the Supreme Court are, recusing themselves. They are, let me say in quote, dodging to be part of the presidential election petition panel, to hear the articles. It's untenable. No matter how much intimidation that is advanced against them, they should stand by the oath of office. The oath they have taken to deliver justice. So the truth about it is that the Supreme Court must at every time be ready to make pronouncements. And let me tell you something, what people don't know, even though this is not in the public domain, but before judgments are written in the Supreme Court, you see, there's a sort of a vote between the justices, between the members of the panel. It is the popular or the majority that a particular justice will now be nominated among those who are in the majority to write the lead judgment, while the other, the minority will now write the dissenting judgment. So it's really not much of a big deal. Let me tell you, if you recall the case of involving Amechi and INEC. The one that made Amechi governor, Rotimi Amechi governor. The Supreme Court didn't have to bother itself to write a long treatise or to support whatever decision it made. And the Supreme Court has adopted that position several times, where after the vote, it takes a majority decision and it says, look, this is the position of the court. We will communicate our reason to you later. It doesn't matter how it goes, how long it takes, for so long as it will write it and then give a support, because that is a constitutional requirement that there must be a reason for whatever decision the court takes. So the court should not create an impression that it is rocket science for it, because these are men who take decisions first before they proceed to go and write the reason why they take those decisions. So why should they unnecessarily postpone the matter? I very much doubt that the Supreme Court will do that, because it may not be able to attend to the barrage of questions and further, incursions, and questions as to how it operates. And that's not a good thing for us.
Well, Frank, this issue of shifting, the date to adjudicate on this Imo matter, it's been in the air. Why is the communications department of the Supreme Court so slow in coming out? They are not strategic enough.
You see, this is an apprehension because by the parties, and the parties here are the People's Democratic Party, that is angling to have its candidate, Emeka Ihedioha, reinstated. But there is also the Progressive Grand Alliance that had its candidate, Ifeanyi Ararume, Senator Ifeanyi Ararume, that came third. But the All Progressive Grand Alliance argued that in the event of the disqualification of Uche Nwosu and then the subsequent sacking of Emeka Ihedioha, at that point, when Emeka Ihedioha was sacked and Uche Nwosu was not a valid candidate, APC didn't have a valid candidate, the All Progressive Grand Alliance is saying that there should be a fresh election. So the likes of Senator Ifeanyi Ararume are expecting that before another election is conducted in Imo in the next few weeks, please, Supreme Court, make a determination whether or not a fresh election ought to have been conducted to replace Hope Uzodinma as per the mandate he had been carrying since 2019. So these are very straightforward issues for the Supreme Court to determine to help us have clarity. But if the Supreme Court adjourns the matter after another election has been conducted, where Hope Uzodinma is actively participating as an incumbent governor, which creates a lot of favor for him. Now, what happens? What happens to the application before the court, which could have been dispensed with before this fresh election? The Supreme Court should not, and I don't agree that the Supreme Court of my country will be subjected to this sort of ping pong by politicians. No, it should be a firm court that makes its pronouncement, that should be respected, that should be looked up to for the certainty, stability, and the peace and good governance of this country. So I don't want to believe that this chief Chief Justice of Nigeria that authorized, that directed in the first place that the matter be heard on the 31st of October 2023 will again be that fickle, like the weather, changing like the weather, and say, no, it should be after the... What basis? It will have to struggle quite a lot to give a reason for that kind of shift within a space of a few days. It will have to give a very strong reason to Nigerians. If not, this doubt, this cloud of doubt about our Supreme Court that is hanging, that is giving every Tom, Dick, and Harry, including those persons who don't understand the judicial process, to be casting aspersion on the judiciary, will increase unnecessarily. I do know that much of that is based on ignorance and marketplace perception. But the Supreme Court should not give ingredients to people to form such kind of negative opinion about it.
Well, thank you so very much, Frank Tietie, a Rise analyst and lawyer there, dissecting, well, what some people just feel that is a rumor or just flying a kite about changing the date.
No, they shouldn't change the date.
Yes.
It's not good for the image of the court. No, it's not.
Thank you very much for coming on Newsnight.